Great, okay, thank you everyone. All right, so my name's Evelyn Dirk and I have an all-star panel for you here which should make my job very easy or potentially very hard depending on what happens. So our topic is the speech clause of the First Amendment and what the court's current turn might mean for the future of the First Amendment doctrine. And we're going to go down from my right in order as you see them. Everyone will talk for about 10 minutes and then give people an opportunity to reply. I think that worked well, and then we'll open it up for questions from the room. So Michael obviously needs no introduction to everyone here. Thank you, Michael, for bringing us all together. And then Judd Campbell from Richmond School of Law, and in a matter of weeks will be my new colleague here at Stanford Law School. Particularly excited not to be the newest member of the faculty anymore, so thank you, Judd, on that count. Genevieve Blake here from Chicago Law School, and then Eugene Volokh from UCLA. So with that, take it away, Michael.
Thank you, Evelyn, and I'd like to thank the organizers of this program for inviting me. So the topic today is the use of history and of various types of history in constitutional interpretation. And I'm speculating, based upon the program, that it must have been the intention of the organizer for us to think across doctrinal fields, so that each of the panels is about a different topic. And ours begins here with freedom of speech, which I think is a particularly interesting place to begin, because I think most people believe that the Supreme Court's copious doctrine on freedom of speech is as little related to history as maybe any doctrine in the Constitution. At least it's quite up there, that it makes very little reference to original meaning or to history of any sort. And this is, I think, particularly odd because the free speech clause is one of the clauses that appears to invite a historical interpretation, because after all it says that Congress shall make no law abridging the freedom of speech. To abridge is to reduce in size from what it was before, and the definite article, the freedom of speech, seems to be referring to a legal concept of, presumably in British and maybe very early American law, of freedom of speech, rather than an activity. Like the freedom of speech is not the same thing as speech, for example, and yet we're in a situation where much of the doctrine seems unrelated. I want to argue that there's actually a lot more history in free speech doctrine than at first appears. I'm mostly going to be giving a descriptive talk, but maybe with a few soft normative reflections at the very end. So after the First Amendment was ratified, the first major free speech, free press controversy was over the Sedition Act. And without getting into the details here, it immediately devolved into an argument about history. So abridging, the defenders of the Sedition Act argued that the freedom of the press was defined by British common law as set forth by Blackstone. The Sedition Act actually liberalizes a little bit from Blackstone. It certainly doesn't abridge the right as described in Blackstone. QED, end of discussion, Sedition Act is fine. Madison, the most brilliant of the critics of the act, does not just say, oh, no, this isn't a historical matter. He immediately jumps into the historical argument and makes serious arguments of an entirely recognizable form. Now, with Jonathan sitting in the room, I hesitate to say it's recognizable. Maybe maybe I'm seeing similarities to modern legal disputation that I wouldn't see if I weren't so blinded by modernity. So what does he argue? He argues first that the Blackstone really didn't have it right. That if you look at the actual law in Britain, that the freedom of the press is wider. He second argues that in the American states, it's even broader than that, especially when you look to practice. And he makes a third, actually this was his first argument, that these difference between a monarchical and a republican form of government has significance, given that the idea of freedom of speech in British constitutionalism, which comes from the British Bill of Rights of 1688, refers to the right of members of the sovereign, that is, members of Parliament, to be able fully to address all matters with among themselves without some outside party telling them what they can and can't say. Well, if the sovereigns in the United States are all the people, then Madison argues for a much broader right for the people to be able to say pretty much what they want to say about public matters. But I'm not going to argue who's right in this interesting historical debate. All I observe is that at the very beginning, our first controversy over the speech and press clauses immediately became a debate about history. Then we go through a fairly long period of time when the Supreme Court barely says anything at all. There's just free speech and free press is just not part of the Supreme Court's agenda really until the Wilsonian attack on freedom of speech in World War I, at which point the court has a few missteps, but begins to take freedom of speech and press seriously. And what it comes up with is something which I would say is rather deeply historical. Now, what they come up with between then and roughly the 1970s, their general form of argument is to find specific areas in which the regulation or limitation of speech is recognized, and then everything else is free. So you have you have a kind of universe of freedom of speech with islands of legitimate regulation, and then that will be replaced by a general idea that any content-based regulation of speech cannot be justified without a compelling interest. We must notice that these are incompatible ways of reading the document, because each of the categorical exceptions, beginning in the 1940s, is itself content-based. What are we looking at? We're looking at libel, we're looking at obscenity, we're looking at threats, we're looking at incitement. Each of those is defined by the content of the speech, and if we really believed that all content-based regulation was suspect, well, the Supreme Court's own jurisprudence was suspect for half a century. I think that's rather interesting. I don't think the court has ever noticed that, but that's rather where we live. I am not going to talk about the history of this idea that content-based regulation is verboten, absent a compelling interest, because I think Judd and Genevieve they've both written about this much more extensively, and I leave that terrain to them. But I want to go back to these exceptions and note how they were justified. So one of the earliest of these is Chaplinsky against New Hampshire, and the court tells us, and I quote, "There are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem." Now, that's a historical argument, a claim that there's certain categories of speech that have always been regulable and therefore still can be. And again, the court does not refer to the language of the First Amendment, but I would just remind you that if the First Amendment prohibits abridgments of the freedom of speech, it makes perfectly good sense to say, well, there's certain things about which we've never had a freedom of speech, and it is not an abridgment of to say that we're going to continue to allow the government to regulate those things. But I would note that the court in Czaplinski went on then to make an observation. It has been well observed that such utterances, they're talking here about fighting words, are no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. So what do we see here? We see an interest balancing idea. So the social value of the speech is weighed against the social interest in order and morality. One might argue, what's the relation between this? They call this an observation. So, the Supreme Court will later, like decades later, looking at this language, interpret it as meaning, well, it's the historical rootedness which is the real legal basis, and then they go on just to comment, to observe that it also happens to pass this interest balancing test. The next case I'm going to mention here is Hague versus CIO, a somewhat different free speech case having to do with public forum doctrine, when people have a right to speak on public property like streets and parks and sidewalks and so forth. And the court explains, this is 1939, wherever the title, that is property title, of streets and parks may rest, they have immemorially been held in trust for the use of the public, and time out of mind have been used for purposes of assembly, communicating thoughts between citizens and discussing public questions. Such use of the streets and public places has, from ancient times, been part of the privileges, immunities, rights, and liberties of citizens. And the court refers to quotes this language from these two cases and a number of other decisions in the ensuing several decades. So it went until sometime around the 1970s. I put the change with Chicago versus Mosley. Maybe those who are going to speak after me will identify the change a little bit earlier than that. I don't know. It doesn't really matter for these purposes, but the court shifts. But looking then at these again, and they shift, and they just simply, they don't go back and overrule the categorical exception cases. They don't comment upon the fact that they were in fact content-based regulation. They just leave these two sort of incompatible and inconsistent ways of thinking about things in place, and they do both. And so when a case involves one of the categorical exceptions, they would use that, and if it didn't, they would go somewhere else, and that's pretty much what was happening for a while. And then, just in very recent times, and I'm saying maybe the last 5 years, the court has become reflective about this practice and has begun to give explanations as to what it thinks it's doing. And so in a case called Stevens versus United States, the court, this is about whether the government, the federal government, could illegalize animal crush videos, the social value of which is probably pretty slim, one would guess, if one were entering into such an enterprise. But in Stevens, the court, by a vote of 8-1 and an opinion by Chief Justice Roberts, and I emphasize the 8-1 here because this is not one of those cases which it depends upon recent personnel changes on the court. This is like almost, Alito is the only a dissenter, and the court basically slams the door on any new categorical exceptions almost. The government in the Stevens case argues for straightforwardly for an interest balancing test. The government says this is Solicitor General, that the court should weigh the value of a particular category of speech against its social costs. Court 8-1 says, no, we're not going to engage in interest balancing. In fact, the court, 8-1, calls this idea of interest balancing startling and dangerous. Not just, it's startling and dangerous, right? And I'm not going to be talking here about the Second Amendment, but there will be a later panel, right? And note that these are exactly the same choices, or at least very similar choices under the Second Amendment. Most of the lower courts have been engaging in interest balancing in gun cases. And in Bruin, the Supreme Court rejects interest balancing in favor of history and tradition. So it looks, Stevens and Bruin look awfully similar, at least from where I sat. And so the court does say there could be new categorical exceptions, but only if there is, quote, persuasive evidence that a novel restriction on content is part of a long, if heretofore unrecognized, tradition of prescription. If this reminds you of Sharif in the last panel, that would be no surprise. A long tradition of prescription might lead to us recognizing a new content-based categorical exception from freedom of speech. Well, this is history, right? Long tradition, ancient times, time immemorial. I won't read all the phrases that they use. But what kind of history is it? What type of history is it, if I may quote the title of the conference? Well, it's not originalist history, right? Because they're not asking anything about what the framers of the First Amendment thought that the First Amendment meant, which is essentially the originalist enterprise. It's also not post-ratification history, because we're actually looking well before ratification to ancient time. It's a kind of traditionalism, though, and presumably changing in much the way Sharif's was arguing that traditionalism does, I think. Now, here's the important point, at least for me the important point, that although these categories are based upon history, the court does not treat them as frozen in their historical form. Instead, within each category, the court has refashioned the doctrine, generally tightening them so as to achieve their historical purpose with the least possible impact on free speech values. You all know the cases. So libel law, New York Times against Sullivan, they accept that that's a categorical exception, but they say that when public figures are involved, there has to be actual malice, and then impose a number of other restrictions in subsequent cases. Fighting words, limited to face-to-face confrontations that may lead to violence. Incitement, Brandenburg, limited to words that are intended and likely to produce imminent lawless action, tightening then the category of prescribable speech. Commercial speech, also an exception, but limited in a variety of ways I can't really describe here, but I think the most important limitation is that the core of legitimate core commercial speech regulation is consumer protection, as opposed to the achievement of other possible government objectives. Now, where did these limits come from? They sure didn't come from history. You don't find the common law cases don't include these limitations, so they're not historically based. I would describe this, and again, this is a description, not a normative position. I would describe this as looking an awful lot like common law development, that you begin with an essential right or principle, and then the court refashions. It's like tweaks here and makes a change there, never departing from the core of the exception, but nonetheless, I mean, another thing it resembles is less restrictive alternative analysis. But where the court is still trying to allow the exception to achieve the purpose that the exception has been understood historically to serve, but in a way which is least minimally invasive to speech. And this, I think, is where First Amendment free speech doctrine seems to diverge from the history and tradition cases that we've been seeing in the last several years from the Roberts Court. Bruin being maybe the clearest example here, where it seems as though the court is going to find history and tradition back there somewhere, and maybe it's even going to be recent, as Sharif argues, but wherever you find it, that's what you've got, right? And that isn't the way the free speech cases have gone. They find the exception, but then they refashion them, not based upon history, but based upon something else. Maybe it's insight, to pick up from Rebecca on the last panel. But it looks like common law reasoning to me. Now here's the extremely modest and tentative normative point that I would like to end with. This might actually be a middle ground position, middle ground methodological position that could bring many of the disputing forces in current constitutional interpretation together, in that it recognizes the real value of history and tradition, doesn't act contrary to those things, but at the same time doesn't have this sort of rigid feel to it, and it does allow for such things as looking at what the impact is going to be under modern technological circumstances. And I wonder, I think it would be an interesting sort of intellectual exercise to look at the Bruin issues, the various gun issues, using this as a slightly alternative methodology in which we do look historically, but we don't stop there. Thank you.
All right, great. Thanks so much. I'm going to talk about an ongoing project that looks at how founding-era elites thought about the role of text and history in determining the legal content of rights, including speech and press rights. And not surprisingly, this is going to build on Jonathan's earlier comments that were encouraging us to reinterrogate fundamental premises of founding-era constitutionalism. I'm especially interested in two questions. First, what is the grounding of fundamental rights? Our answer to that tends to be text, but that's not necessarily their answer. And then secondly, how did enumerating rights textually in a constitution affect the boundary between law and politics? So our answer to that is that enumeration fundamentally marks a boundary, turning questions into legal questions that might otherwise be political. Again, maybe not their answer. So I'm going to start with two key punchlines and then talk about a couple of the key moves in the project and then conclude with a comment about Bruin. The first key punchline is that constitutional text could serve two different functions. So one of those functions was to simply declare the existence of rights that actually were grounded in some other source of law, in particular reason or custom, or nature and custom, without actually specifying the legal content of the right. But there also could be textual determinations. And so both of those modes of enumeration were available at the founding. The second key punchline is that, at least for the most part, the Federal Bill of Rights is declaratory, and therefore it is a mistake to read it as a principally textually based object. Some rights were thought to already have determinate legal content, and that legal content could be judicially enforceable in some respects under fundamental customary law. So Michael has already alluded to this. The freedom of speech and freedoms of press have at least some customary content, including a right against prior restraints. But for the most part, the point of enumerating the speech and press clauses was not to remove from the realm of politics other decisions about how to determine the boundary of governmental power over speech and press. So that's the basic thesis, is that the Bill of Rights is mostly designed to declare rights that exist under custom and nature, and that remained underdeterminate to varying degrees, with the determinations to be settled through political judgments, not through judicial decisions. In other words, the text is serving as a placeholder for rights that are grounded on something else. Of course, this presupposes that rights can be grounded on some other source of law, something that we're often unfamiliar with. And so to recover this way of thinking, we need to return to older ways of approaching ideas like natural law and natural rights. And to make things simple, I'm just going to highlight two key points here. The first is that founding-era elites thought that natural law and natural rights, although they existed, they were largely underdeterminate, and that positive law was needed to intervene to specify particular aspects or legal content of those rights. So, for instance, the natural law says that you have to have capacity to consent to enter into a contract, but it doesn't actually determine what the age of consent is. And so you need positive law to come in and say you have to be 21 years old in order to consent to a contract. Really crucially, this is internal to their way of thinking about law and way of thinking about rights. So underdeterminate rights exist, and then legal specification is needed in order to give those rights specific content. All right. The second point is that basic principles of republicanism that were widely accepted at the founding made clear that the people themselves have to make the determinations. And there are a couple ways of doing this. So one, of course, is to have representative assemblies pass laws that specify the legal boundaries of natural rights. Another is through juries, which are seen at the time as being representative institutions. And then finally, but perhaps most importantly, is the idea of custom, that long-standing customs are said to reflect the consent of the people themselves. And on this view, judges could discover those customs, but judges were not in charge of actually determining, in the metaphysical sense, the boundary between law and politics. Judges are discovering what the freedom of speech means when ascertaining the legal content, but are not actually actively creating it. Importantly, some aspects of this customary law are seen to be fundamental in character and therefore not subject to legislative modification. I've already given an example of this. The freedom of the press entails at least a right against being subject to prior restraints, which is a common law right, but one that was thought to have fundamental status in the Anglo-American Constitution. So there's this background idea at the founding that some rights have fundamental status but are grounded in nature or custom, with neither being required to be textually specified in the Constitution, which then leads to the big question, what's the point of writing down rights in a Constitution? What's the legal upshot of that? And what I argue is there's not just one right answer, that you could have a declaratory enumeration of rights that did nothing to change the legal content of those rights, nothing to fix the legal content of those rights, and the rights themselves actually remained grounded in reason and custom. This is the dominant mode of enumerating rights at the founding that legal historians like Jack have written about. But there's also another mode of enumeration, which is to use the text as a way of making determinations, of specifying the legal content. So, for instance, James Iredell said during the ratification debates that the framers could have, quote, determined what punishments could or could not be imposed on criminal defendants by just textually listing out which punishments you could impose or which punishments you couldn't. I should add, Iredell thought this was an incredibly stupid idea. He said that providing such a labyrinth of detail in the Constitution would have been, quote, perfectly ridiculous. But my point here is simply that this was an available mode of enumerating rights. They could be declaratory or they could be specificatory. And in the lead up to the drafting of the Bill of Rights, many anti-federalists proposed simply for enumerating declaratory rights. Interestingly, Thomas Jefferson was not among them. Jefferson was a fan of codification and thought that writing down and specifying through text legal limits on governmental power was possible and wise. And so he wanted to create provisions like an amendment that would specify that printers would not be liable except for false facts printed, actually using the text to determine the boundaries of governmental power. And here's the rub. Jefferson lost. When Madison and his colleagues convened in the first Congress, they reject almost across the board the idea of using text to specify or change the legal content of rights, and instead simply offer declaratory amendments, ones that simply make reference to some other provision or body of law like custom or reason. Specifying a right is, in Madison's view, not viable and potentially even counterproductive, and so simply declaring that Congress shall not abridge the freedom of speech or of the press, in his view, is a better idea. These are, according to Madison, quote, simple acknowledged principles, not ones of a doubtful nature. So what we see then is an effort not to textually specify or fix fundamental rights, but rather to make reference to rights that remain grounded in reason or custom. And it seems to me to conclude that this offers a very different way of thinking about fundamental rights than what the Supreme Court presupposes as the basis for its view in Bruin. So the court assumes in Bruin that text is the grounding of rights and that the content is based on whatever is textually specified, minus whatever history tells us is actually within the realm of governmental power. The underlying premise here is that rights are textual and that rights are immune from governmental regulation. I think that something like that was available to the founders. I think that that was what Jefferson wanted and that Jefferson lost. Thanks.
Hello, everyone. So I'd like to say thank you to the organizers for having me, but I genuinely mean it this time since I'm not one of the organizers. It's really a pleasure to be here. And I appreciate also being on a panel that's about free speech and the First Amendment at a conference that is not just about free speech and the First Amendment, because First Amendment jurisprudence often gets, I think, segregated or ghettoized into its own domains, which is fun for us free speech people. But I think, as Michael's comments noted, there are ways in which there are continuities that are interesting between First Amendment and other areas of law. And it's great to be at a conference where this can be demonstrated or illuminated. And I'm actually, in my remarks, I'm going to make very similar arguments to the arguments that Michael laid out, or talk about similar things. But because history is a story, I'm going to craft my story a little bit differently to reach different conclusions. And so you'll see that we're using very similar materials to tell a somewhat different tale. So my remarks, I'm going to argue that, like Michael, that history has always played an important role in First Amendment jurisprudence, or at least since the emergence of the modern First Amendment in the early 20th century. There's nothing new. Invocations of history litter the cases from the 1930s and 1940s, in large part because, as I'm going to argue is true still today, members of the New Deal Court made historical arguments to justify what were, in fact, significant departures from the doctrinal status quo. History of a certain kind, what we might call, in this context, deep dive history or underlying purposes history, was used to combat and vanquish another kind of history, the precedential history that is characteristic of a common law system organized around the principle of stare decisis. Stare decisis, precedent, was a problem for the New Deal court. They wanted to revolutionize and reinvent the First Amendment, and the way in which they did so was by relying upon a different kind of historical claim. This becomes evident from even a quick glance at some of the most important early 20th century decisions. Consider, for example, the 1940 decision in Thornhill v. Alabama, which effectively created the First Amendment doctrine of overbreadth. As its critics are wont to point out today, the doctrine of overbreadth is a judicial invention. There is no evidence that prior to the 1940s, courts recognized the First Amendment to permit litigants whose free speech rights were not violated by the application of a particular law or state action to challenge the law because of its effects on the rights of others, which is what the overbreadth doctrine allows. Yet in Thornhill, the court relied heavily on history to justify its invention of this extravagantly speech protective rule. Specifically, the court turned to the history of administrative licensing and to the struggle against administrative licensing waged by early advocates of freedom of speech and press, including specifically John Milton. It drew from this history the principle that, quote, it is not merely the sporadic abuse of power by the censor, but the pervasive threat inherent in its very existence that constitutes the danger to freedom of discussion. And it relied on that principle to justify not just the old rule against prior restraints, which it did not contest, even though it was reimagining it, but the new doctrine of what will come to be known as overbreadth. History in the Thornhill court's hands revealed a principle that justified a rule that was not itself historically established, but that was instead logically consistent and required with the aims that motivated the ratification of the First Amendment and similar free speech guarantees. Now, history underpinned the court's reasoning in Thornhill. It is noteworthy to note, not only when it came to the overbreadth doctrine. The court also relied on history when analyzing the important question of what kinds of speech and expression fall within the scope of First Amendment concern. And Thornhill here, too, is a sort of core case in establishing the rules that guide scope questions, coverage questions. Specifically, the court relied upon historical understandings of the First Amendment's purposes, and more specifically, the discussion of those purposes contained in the famous letter that the Continental Congress sent to the inhabitants of Quebec in 1774, imploring them to join the revolution in part because of the liberties it was intended to guarantee. It relied on this evidence to justify its expansive and at that time quite controversial holding that labor pickets were entitled to First Amendment protection. This, again, was not within what the Continental Congress understood the letter to require, but it was consistent with the principles articulated in that letter, in particular, the idea that the First Amendment is important to arm the citizens with critical information about their government. Similar moves were made in other decisions from this period. The court relied on historical understandings of the First Amendment to justify its conclusion in Bridges v. California that the First Amendment significantly limits the ability of courts to impose contempt sanctions on litigants who criticize their rulings outside of court, even though, again, this was a new rule. And somewhat later, in its famous decision in New York Times v. Sullivan, the court relied on history in exactly the same way it had in Thornhill and in Bridges v. California. That is to say, it identified a historical principle, one that it deciphered in the intense debates about the constitutionality of the Sedition Act of 1798 that Michael referred to justify what was an entirely novel rule, namely the requirement of proof of actual malice in libel cases against government officials. Now, relying on history to make sense of the sparse and ambiguous text of the First Amendment has, therefore, I think, a long history of its own in the First Amendment cases. But the court's use of history has changed over time. And we might designate this is the sort of history I will tell, as a movement from what we might think of in Thornhill, in Bridges, in Sullivan as underlying purposes history or grand principles history, to what Sharif earlier called living traditionalism. And the shift, which has occurred, as Sharif makes clear, in many different areas of constitutional law, occurred very early in the First Amendment context. And that was going to be one of my punchlines, but Michael already spoiled it, because it's United States v. Stevens where we see this happen. And so we can see this if we contrast the Thornhill court's use of history or the court's use of history in New York Times v. Sullivan with the way the court used history in its 2010 decision in United States v. Stevens. In Stevens, as you all now know, the court was asked to decide whether a law punishing depictions of cruelty to animals violated the speech clause of the First Amendment. And it concluded that it did because In part, it found that depictions of animal cruelty had not been historically regulated in the United States. From 1791 to the present, Chief Justice Roberts declared for the court, the First Amendment has permitted restrictions upon the content of speech in a few limited areas and has never included a freedom to disregard these traditional limitations. Okay, so history is both a floor and a bound. To figure out whether speech can be regulated without triggering strict scrutiny or presumption of unconstitutionality, the court instructed lower courts to look not at the purposes of the First Amendment, not at the grand overarching principles that underpin the long struggle against monarchical repression and administrative control. The opinion instructed courts that they had to look at the traditional practices of legislatures, regulators, and courts in the United States to figure out what they revealed about the constitutional status of different kinds of speech. This is a very different use of history than the use the Thornhill and Bridges and Sullivan courts made. Not only does the focus of the inquiry shift from underlying purposes or grand claims of purpose and principle, usually articulated in texts that are themselves self-consciously about freedom of speech and press, the letter of the Continental Congress, the debates about the Sedition Act, the claims of early drafters of state and federal constitutional guarantees. It shifts from these self-conscious discussions of the meaning of these rights to historical practice. And chief among these, the practices of legislatures, many of which may not have been self-consciously about freedom of speech at all. And these practices are then used to establish evidence of what the Stevens Court described as a, quote, long settled tradition of subjecting that speech to regulation. Okay? So we have a very different kind of historical inquiry with very different objects of historical concern. Our focus has shifted. More importantly, though, it's not just that we are looking now at different kinds of things and we are focusing on the actions of different kinds of agents. The agents who populate history have shifted. The role that history plays in the judicial analysis is now a very different one. So under Stevens, historical evidence operates as a fetter on judicial discretion rather than as a justification for doctrinal invention. That is to say, as Michael made clear, without evidence of a long-settled tradition of subjecting speech to regulation, the presumption is that speech is fully protected by the First Amendment. And therefore, absent this kind of evidence of alternative ways of being, courts have to apply the default rule that the Supreme Court had established in earlier First Amendment cases. Now, whether or not Stevens in practice operates as, and this was very self-conscious on the part of the Stevens Court, which, as Michael made clear, is very worried about this idea of judicial discretion and what it calls the use of ad hoc balancing, which it calls startling and dangerous. And so it uses a historical test as a means of limiting and constraining the freedom of courts. Or at least this was the intent. As I've argued in some of my writing, in practice, judicial discretion, judicial invention is not so easily fettered. And this is the case for at least two reasons. One, because the historical record is not always so easy to decipher, and because the court itself has not been clear about what kinds of historical tradition are required to override, to take speech out of the protection of the First Amendment. Do you have to go all the way back to 1791? Is it okay to go back to 1891? What do you do about updating? These are the questions that courts in the wake of Stevens have struggled to decipher. But it is also the case because a faithful application of the Stevens rule leads to conclusion that courts are not always ready to stomach. The result has been the emergence of what looks like clever workarounds in the lower courts. And here I think I'm echoing but also altering a little bit Michael's conclusion that in the wake of Stevens we've seen continuing refinement of the categories and in particular their limitation. I think in most of the limitation in the low-value speech categories that Stevens identifies occurred prior to Stevens, occurs over the course of the 20th century. In the wake of Stevens, we have seen, in fact, I think the opposite. We've seen the expansion of some of the categories, and in particular, the lower court's use of the category of speech integral to criminal conduct, or the conduct-speech distinction, as a way of dealing with categories of speech that courts think very reasonably need to be regulated, because they are forms of speech that are newly harmful or it's a response to novel technological situations, but that you simply cannot justify under the Stevens test. And so we are seeing in the lower courts really creative efforts to transform what once might have been considered to be speech now to be treated as conduct or speech integral to conduct as kind of intermediate category. The result is a very messy and often quite incoherent body of law, and one that I think it's important to note for purposes of this conference, does not get courts any closer to a historical understanding or historical practice of freedom of speech. This is because even if applied in a principled manner, what the Stevens test produces is not a doctrinal framework that looks anything like the doctrinal framework that governed free speech and First Amendment cases in the 18th and 19th centuries. In fact, it looks very, very different. If in the 19th century the general rule was that speech could be regulated so long as the government could identify a public welfare justification for doing so, and courts were quite deferential to government interests when figuring out whether there is such a justification, the Stevens rule means that speech generally cannot be regulated, certainly not in a content-based manner, unless some pretty extraordinary conditions are met. So again, in Stevens, what we see is the invocation of history to justify what I think is a very significant break from the past, not a continuity with it. Okay? Now, this raises all kinds of questions if you buy my retelling of the history. The first is, well, I suppose the first conclusion one can draw from this is that one should be suspicious of extravagant claims of historical fidelity, particularly by the Supreme Court. When I see such claims, I immediately wonder whether there is, in fact, what is going on is a break, a doctrinal transformation. History stepping in where precedent and stare decisis, which are, of course, easy to rely on, fails. Normatively, though, this telling raises the question of why we might want to use history in this way. What the Stevens rule does is to stack the deck quite strongly in favor of a libertarian model of speech regulation that is very different from the majoritarian welfarist model of speech regulation that we see in the 18th and 19th century cases, in the treatises, in all the writing about freedom of speech and press during this time. It creates a speech regime that we may like, right? We may be committed to a libertarian conception of freedom of speech. We may be modernists. Or we may not like. We may think it's unduly restrictive of government power. But one that is not justified on its own terms, but is justified on historical terms, but a history that never existed. Now, this new regime is conservative in one sense of the word. It conserves, in many respects, the doctrinal status quo that the court has established in its recent cases, this very strong presumption against government regulation of content-based speech, by making it extremely difficult for the lower courts to identify new exceptions to the general rules that the court has read into the First Amendment. It's conservative insofar as it conserves, I think, the Supreme Court's power and its ability to declare the limits and the scope of First Amendment protection. But this has costs and consequences of its own. And it is not conservative in the broader sense, in the sense that it is conserving a long-standing, longue-durée, multi-century tradition of free speech. And it does so without obvious connection to the purposes and principles that the historical record suggests or reveals. And this is, I think, a problem. I will put my cards on the table. Like the justices who joined the opinions in Thornhill and in Sullivan and in Bridges, I believe that the historical record of the fight between licensors and publishers, and later the fight between radicals and regulators, that this historical record reveals important problems and concerns that should, in fact, motivate free speech jurisprudence today. I think history should, in fact, play a role in free speech jurisprudence, both at the Supreme Court level and at lower courts. Right? This history suggests, for example, that viewpoint discrimination by the government can be a big problem, particularly when applied to public discourse, that we should be attentive to the chilling effects of overly broad or overly vague regulations, that we should be wary of majoritarian speech regulation, including by juries, that the jury system as a means of defending dissidents against government power has not worked very well. These are useful insights that the historical record gleans us. But using history as a cage for the lower courts not only fails to effectively constrain judicial discretion, but distracts us from the central lessons that history has to teach us by pushing us away from this discussion about what the principles of the historical record are, to these often quite orthogonal questions of whether or not a particular form of speech was regulated in the 19th century and how. So if the question this conference poses is what kind of history, my answer is not this kind.
Thanks very much for inviting me to be on this panel. I'm primarily a doctrinalist. I'm not a historian. And I care about the law as it is now, and although the history has, of course, affected it. At the same time, I entirely agree with Michael and Genevieve that history has, rightly or wrongly, thoughtfully or not so thoughtfully affected the thinking about free speech. And I wanted to go back a little bit. But before I go back far, I want to go back to yesterday, literally yesterday. There's the Supreme Court, of course, yesterday decided the Andy Warhol copyright infringement case. And there's very interesting opinions. The majority opinion by Justice Sotomayor, the dissent by Justice Kagan, quite acerbic, more than some might expect from copyright opinions, but there it is. Justice Kagan was arguing that the majority had departed from precedent. And the precedent was precedent having to do with the fair use doctrine, and in particular the question of when a particular work is transformative enough. And here, whether particular use by Andy Warhol of a photograph by, I would say, Lynn Goldsmith in any case, whether that was transformative or not. So Justice Kagan has this line here that in adopting their position, the majority does something novel. Though in law, unlike in art, it is rarely a good thing to be transformative. So this is very much a lawyer thing to say, or certainly very much a judge thing to say. Even when judges try to transform things, as Genevieve points out, they often look to history for cover. Because, and there's another version, although I do not know whom to credit this to, but the version of Kagan's line, which is, law is the only discipline in which the phrase, that's an original idea, is a pejorative. So we look to history, judges look to history to legitimize things. That's sometimes a rhetorical tool, sometimes maybe even an internalized rhetorical tool. They like to think that they are maintaining kind of a broader and deeper tradition. And I wanted to mostly talk about one particular example of this. It's just one example, but I think historically it had been a pretty influential example, and I thought it might be of some interest. It may also help shed light maybe a little bit on what we're talking about with regard, we'll be talking about later in this conference, with regard to whether you look at 1791 history or 1868 history. Because it's going back, basically, I think 1868 was the first edition of Thomas Cooley's Constitutional Limitations, and then went through many editions afterwards. Thomas Cooley was a law professor, so we have to like him for that. He was also a Michigan Supreme Court justice. I did a quick search, there are some false positives, but apparently in the first 50 years of his treatise on constitutional limitations, it was cited by courts in, I want to say, 7,000 cases. That's a lot of citations. I'd hire him. He also wrote quite early on in American legal history about free speech. Obviously, this was already 80 years into the First Amendment and coordinate state constitutional provisions, even further into some of them. But it was actually at a time when there was relatively little free speech case law, free speech and free press. There had been some, generally in libel cases and in contempt of court cases. And at times, it was mostly a means of trying to, it was used mostly as a means of trying to shape common law decisions. So there were, for example, some libel decisions that cited free expression guarantees early in the 1800s as a justification for developing what one might think of as certain privileges today and such. So he begins by talking very much like Michael McConnell. He says, look, the First Amendment secures the freedom of speech or of the press, and it's observed of these several provisions that they recognize certain rights as now existing and seek to protect and perpetuate them. So he very much accepted this notion that there would be, that this was declaratory of existing rules. But, and here I think he may disagree in some measure with Judd, in a way that really was judicially enforceable. Although at a time it was very rare to have them be brought up as objections to statutes or ordinances. My recollection from when I last looked at it is the first time that an American court struck down a statute or an ordinance on free speech grounds was actually in the 1890s. So it actually took quite a while. But still, he was talking about it as a judicially enforceable right. He says, look, how do we figure this out? Well, first of all, we look at the common law, and we see, for example, there is, as Judd points out, a long-standing prohibition on prior restraints. Well, that administrative licensing system, that should certainly count. But then he says, well, it isn't just that. It can't be just a prohibition on prior restraints. By the way, the Supreme Court, as late as I want to say the 19 teens, certainly in Fox v. Washington in 1905, the court just blithely said, well, it's all about prior restraints. But already some objection to this prior restraint-only model was well established there. So Cooley was saying, look, the whole goal is to guard against repressive measures by the several departments of the government. So that would presumably include legislatures. The constitutional liberty of speech and of the press, therefore, is a right to be protected. But of course, with the understanding there would be exceptions. What exceptions? Well, also defined by the common law. The examples he gives is blasphemy, obscenity, or other things of a scandalous character. And for he also adds libel to that at the just a couple of paragraphs down. And he says there's complete immunity for legal censure and punishment for the publication, so long as it is not harmful in its character. How do you decide what is harmful? When tested by such standards as the law affords. And for these standards, we look to the common law rules which were in force when the constitutional guarantees were established. So at least ostensibly very much an originalist model at that time when the relevant provisions were less than a century old. And then he goes through and talks about the common law rules. Chiefly he talks about libel because that was actually the issue that the readers of his treatise would probably be most interested in. This, I think, is a good early example of the kind of historical thinking that we'll talk about the court sometimes invoking. Since then. One other thing that's interesting is when he goes through the various common law rules, he talks about the rules of libel, which were then very much established and had been refined in many ways by courts since then. He mentions, as I mentioned, obscenity and blasphemy. And then, of course, he has to talk about seditious libel, which is a little bit of an embarrassment, right? Because at the time, if you really look back at the common law, there was well-established, Blackstone talks a lot about it, the doctrine of seditious libel, and yet he was one of the people eventually the court cited for the proposition that no, the Sedition Act was really a departure from true First Amendment principles. And so you have what is actually very, very much like what you could expect the court today, and with effect the court maybe not so much today, but at least the courts in the 50s and 60s basically talked about, in various contexts, saying, well, look, this just, whatever the old English rule might be, just isn't consistent with true American Republican principles. And how do we know that? One is by a matter of just sort of reasoning through the understanding of Republican government, and another is through tradition, through kind of the common judgment of the American people, as Cooley interprets it, since the Sedition Act. So that, I think, is obviously a vastly oversimplified version of it. He has 60, 70 pages on this in his treatise, of kind of free speech thinking before modern free speech doctrine. It was entirely before the Supreme Court's modern free speech doctrine, or any real free speech doctrine from the Supreme Court, and before the overwhelming majority of free speech doctrine that has been developed since by lower courts as well. So one thing that we see is a total lack of attention to a lot of the subtler questions, like how do you deal with various kinds of content-based or viewpoint-based or various other kinds of restrictions. There's no real discussion about the government acting as proprietor or employer. All the things that the court has had to deal with, there just wasn't much occasion for him to deal with it. He wasn't a political philosopher. He was a treatise writer. He was a lawyer, a judge, a law professor. He was writing about things that were actually in play at the time. But I do think we're seeing a combination of two things. First of all, we're seeing the embryo of the modern First Amendment doctrine, the existence of a broad protection for speech, subject to a set of exceptions, which are in many ways quite similar to the ones we see today, with some exceptions. So blasphemy has been categorically rejected. Others have been narrowed in various ways. But we see that general structure, and we also see this enduring appeal to history, to the notion that we ought to be protecting the liberties that our forefathers had kind of secured for us. How fictional that was even then, hard to know. How much sense it makes now to try to combine this history with all this non-historical development, and I entirely agree with Genevieve and with Michael that a lot of current doctrine, even if influenced by history, certainly is not tied closely to history, and may sometimes be a departure from precedent, a departure from history, and at the very least, innovation. So it's not clear whether the court has done much good history since then. It's not clear if it even was good history back then. But I do think it's an example of kind of the enduring appeal of these kinds of historical arguments. So the last question is, what do we do with it now? What do we do with this tradition of trying to reconstruct in some measure a historical First Amendment right that was secured in 1791 based on the common law of the time? I have to say I'm not super enthusiastic about it. I think that especially with the sheer weight of current doctrine, it becomes very difficult for the court to go back to a really historical approach. Whatever one might say about a historical approach in Bruin, the Second Amendment issue, which we'll talk about later, there isn't the same weight of Supreme Court doctrine to be unraveled. Here it is a tremendous amount. If the court is to try to unravel some of it here or there, it would end up doing it in a highly selective way, unless it is willing to really go back from scratch and saying, you know, go back to Cooley or go back to before Cooley. And I just don't really see an appetite on the court's part for this. So being a doctrinalist, I kind of like the doctrine. I mean, normatively, I like most of the doctrine the court has set forth, so it's easy for me to say that. But I'm inclined to say that it's unlikely that the court is really going to return to history in a big way, as opposed to in particular narrow areas where it's possible that libel law may be cut back to based in part on some historical roots that it has. But I don't think it's likely to happen much. I don't think it ought to happen. But I do think that this notion of the First Amendment as being basically, as Michael described it, as being a preservative principle that, contrary though to Judd's views, Judd's views may be correct, this notion may be wrong, but that's been set up as a means of essentially it's a judicially enforceable check on the government, has been around for a long time. It seems likely that at least the rhetoric of it will endure as well.
Okay, great. So before I open it up to the room, I just want to ask any of the other panelists if they wanted to respond. In particular, I'm grateful, Eugene, for you ending on that point, because part of our brief for this panel is to talk about the future of the First Amendment and not merely the role that history has played in the past of the doctrine. And so I'm curious to hear other people's thoughts if they agree with Eugene about the the role that history might play going forward, whether the First Amendment might be immune or just too solidified to upset, and whether that means that we go back into our little First Amendment ghetto that Genevieve put us in, or said that we're normally in at conferences. So curious. Yeah, John.
I'll start off with 2 quick points. So the first is Genevieve and I both emphasize the general regulability of speech, and Michael and Eugene emphasize the non-regulability, at least absent certain categories. I think these 2 views are actually ones that we can synthesize historically. In addition to the rule against prior restraints, there's also a principle that well-intentioned speech on matters of public concern was privileged. And what the exceptions are doing is providing categories in which it was deemed not to be well-intentioned speech on matters of public concern. Very importantly, though, they didn't start with a premise that anything that one would define as speech within a dictionary-based definition is presumptively immune from regulation. Rather, it's anything that's well-intentioned speech on a matter of public concern is presumptively immune from regulation. And the court backs away from the manageability of a public concern category and backs away from the well-intentioned speech dimension, which then just radically transforms what the government's ability to regulate is. And so I think that where we are now is fundamentally different, even though it is true that there is a long-standing tradition of using historically based categories.
I guess I'll just say, and this, I think agreeing largely with Eugene, which is that the traditionalist approach that the court uses in Stevens, as I said in my remarks, gets us very far away from what someone in 1795 would have understood freedom of speech and press to mean, applying either the state constitutional guarantee or the federal constitutional guarantee to the extent it is relevant. And it's interesting to think theoretically about the relationship between traditionalism and originalism. I know that came up at the earlier panel. In the First Amendment context, what I read Stevens' traditionalism to be, and there is some kind of discursive connection to originalism because the language in the opinion says from 1791 to the present, these are our traditions. So there is an effort to anchor this in 1791. It doesn't just say there has been this long-standing tradition of free speech protection. 1791 is a relevant date in the Stevens opinion. But the result is something that looks very different from what free speech would have been understood in 1791. And so I read traditionalism as an escape from the real political and maybe normative costs of going back to something like an original understanding or an original meaning, which would I think require us to permit there to be blasphemy laws and produce a much, much more repressive speech environment than we are accustomed to today. I think going back to an original understanding would be a radical shock. And it's very hard for me to imagine courts doing it, but this raises this question about what originalism means in the First Amendment context. And I think it helps explain why what we get in First Amendment cases is traditionalism, or as we saw recently in the Fifth Circuit opinion in the net choice case, a move towards a kind of let's begin with the original understanding that is one paragraph long and says, let's look at the original understanding. Oh, the original understanding doesn't have anything to do with the regulation of social media. Thank God, let's move on to something else. And so it suggests a real tension between originalism and traditionalism.
Michael, did you want to?
My crystal ball is not very good. So what are they going to do in the future? I think there's another thing going on, which I see bothering. I don't actually think the justices are very much worried about most of the things we've been talking about. And so they're probably not going to change on any of these. Something that I do see them worried about, though, and having to do with content, the category of content-based regulation is I think many of them are seeing that category is both over and under-inclusive in very troubling ways. Under-inclusive because it's becoming, I think it's pretty apparent that time, place, manner, and speaker classifications are easily used for all the, speech suppressive things that content has historically been. And so And so in this sense, just allowing those things to go by on a reasonableness basis is, I don't think that's gonna, I think that's gotta change. But I also think that it's over-inclusive in that there are, and this is especially something that I think Kagan has been big on, is to see that there's so many instances in which content-based regulation is entirely innocuous, and to try to apply strict scrutiny to it is silly and maybe even worse than that. And so I don't really know where they're going to go, but I'm guessing that we have come. We're approaching the end of a regime in which content is the key distinction.
Okay, great. Let's open it up to.
Could I ask Judd just one question?
Sure.
So, Judd, how do you know that the Bill of Rights is so declaratory? Because, I mean, I recognize the distinction, and especially when you look at England in the 1688, the English passed both an English Bill of Rights and also an English Declaration of Rights, which is kind of where I get my sense of what the difference is. And the Declaration of Rights was a parliamentary restatement of what they thought the law already was, and it did not require the assent of the king. The Bill of Rights were changes in what they thought the arrangements were, and they forced King William to sign the Bill of Rights basically as a condition to becoming king. So it needed royal assent. So changes versus sort of declarations. But when I look at the U.S. Bill of Rights, a lot of it looks Bill of Rights-y rather than declaratory to me, beginning with the First Amendment where it says Congress shall make no law abridging, et cetera, et cetera. Well, that doesn't sound like it's a reference to, some sort of natural law principle. That sounds like it's an actual legal principle to me. And, when you go through all 8 of them, I think there's probably some that are in each category, but I would guess that more of them look like legal specifications than look like vague declarations to me.
So 2 comments. One is I do think that they're both. There are some provisions that are trying to specify some limit. I think the Establishment Clause is like that. Certainly the amount in controversy aspect of the 7th Amendment is like that, specifying something new that didn't exist before. And it's just an empirical question as to whether or not the provision at issue is one that is restating an existing principle of customary or natural law, or one that's actually trying to modify that law in some way, fix it in place. The other thing I'll say is I resist the sort of it's either declaratory and non-judicially enforceable, or it's specificatory and judicially enforceable binary that you were trying to trap me in. I think there are declaratory provisions that include customary law that was well settled and judicially enforceable. And I think the rule against prior restraints is an example of that.
Great.
Hi, Eric Rosbach. I guess building a little bit on what Eugene was talking about with the idea of the court maybe not being happy with the 1950s and 60s way of viewing the free speech clause, and also just the general trend of the Bill of Rights sort of turning towards history. History's kind of been marching through the 6th Amendment and the 4th Amendment and things like that. And let's just posit that some members of the court see there's an anomaly with the free speech clause. Where do you think you would see the sort of first nibble at that? And I think Eugene was suggesting maybe libel law, New York Times against Sullivan, and also whether such nibbles might occur in the pending 303 Creative case, which particularly has history front and center, but it's the history of public accommodations laws, right? Colorado's main defense is a historical defense of public accommodations laws. So I'm just wondering whether that might be a place you would see some turn towards history with respect to the free speech clause.
I don't really see the 303 Creative as being much about history. It's about this fight between public accommodations law, anti-discrimination norms, and this idea of expressive autonomy, which is itself, I think, relatively new. And so I think on both sides we have a relatively new legal regime, and there's going to be this question about how are we understanding the relationship between the two. I'm not sure. I mean, I think I'm with Eugene that we're not going to see a transformation. I think First Amendment is going to be relatively immune. I think there's going to be language about history, as I've suggested, and I think Stevens is a very useful framework that I would be very happy if Michael's correct and the court backs away from its current very rigid approach to content-based regulation and the regime created by Stevens, but I don't think it's likely to. I mean, Justice Thomas has suggested places that he would like to nibble. So it's not just New York Times v. Sullivan. He suggested that overbreadth should be either abolished or limited significantly. And we're going to have an overbreadth case handed down this term, Hansen, and maybe who knows what's going to happen. But even then, I mean, overbreadth plays such an important role in contemporary First Amendment jurisprudence, it's hard for me to imagine that it would be abolished. Perhaps there's going to be language, like we've seen before, that it should be used sparingly, it's the nuclear weapon, let's limit it, but that's still very much at the edges. I'd be curious if other people disagree, but I just think the First Amendment's going to be pretty immune, in part because there has been such profound transformation in judicial understandings of what free speech requires.
I'd be very surprised if 303 Creative is a place where they turn to history. I bet we don't hear any history at all in opinions in that case. It's all, I see it all as being doctrinal. I do think New York Times against Sullivan is, lots of people from different directions are raising questions about it. But I also think that when they look deeply into that pit, that they're going to find that there's some things they don't want to get rid of, and I think the most likely thing that they would do is to cut back on the over-exuberant definition of public figure, but I'm not sure that they're going to do much else about that. It's sort of free speech, but I guess more religion. An area which I thought was particularly ridiculous is, although I didn't disagree with the holding particularly, but in Kennedy versus Bremerton, the Coach Kennedy case, the idea that you look to history and tradition to decide cases about whether public school coaches can kneel in prayer at the 50-yard line after a game when their teams have gone off to the locker room. I just don't even know where you'd begin with the history and tradition there, since there was open, public school teachers led their kids in prayer up until about 1963. So it just seems like the most improbable place to use the history and tradition approach, and yet that's one of the ones where they flagged it.
One thing about the libel cases is it's just an example of where the law seems to be most directly contrary to history and tradition. Not just not supported by history and tradition, but directly contrary to it. Especially when it comes to public figure status, as Michael points out. There was at least some tradition starting with the late 1800s of some degree of extra protection for speech about political figures and about candidates. But about public figures, my sense is that it's really quite weak. Of course, the most prominent critic of Sullivan on the court and of expensive libel law was Justice White, who was no originalist by any means. So there's also just general dislike of what is seen as some of the excesses. So combine those two things, kind of a normative disapproval among many of the current rules, coupled with it being directly contrary, that I think makes for the strongest case. That's why I think there's at least some chance, a chance of that. You could imagine, here's one other example. You could imagine a court case that upholds revenge porn laws and possibly the laws that are being passed to ban deepfake porn, reviving in some measure the obscenity exception and saying, you know, we don't need to decide whether there's a compelling interest or not. You know, there is this long-standing tradition of treating sexually themed expression differently. That its home is in the obscenity exception, and while obviously it's been cut back in many ways, and you know, there's been a war on porn and porn has won, nonetheless, this is a point where the insight that sexually themed speech, especially when you don't have consenting adults, because somebody's not consenting to being depicted, is sensible. See all these historical statements about obscenity being an exception. That's, I think, another example of where it seems a little more likely that there will be some sort of historical reference.
Hi, Reva Siegel from Yale. I wanted to thank the panel for a fabulous run. I wanted to spotlight a provocation in Genevieve's remarks because it feels like it's maybe going under the waves. So I understand you to be doing something like pointing out that when judges decide cases, they're doing law and they're not historians, and that the appeal to the past is in the service of doctrinal change. It's the substance, you know, it's about disrupting law. Mm-hmm. And with that, I wanted to observe that I think that's essentially correct. And I've talked about this in the form of constitutional memory claims, which is to say, when we're arguing with one another about who we are and what we have to do together, how we live together, we make claims about the past as a part of that essentially normative practice. Now, those claims can be tested historically. You know, these claims about the past, we could say they're true, we could say they're false, we could say they're selective, we could say they're interpretive, we could say many things about them. We could be historians looking at the claims on the past that judges are making, but when judges are deciding cases, they're doing the insight thing. They're doing the normativity business. And we shouldn't lose track of that. So then you pointed to that more or less, and two styles of making claims on the past. And I wanted to also spotlight that. So the first that you were talking about is looking to the past as a source of an understanding of who we are as a people, the appeal to which is in the form of principle or purpose. So values on the surface of it, and the appeal then can be tested. Are we this kind of people or not? We're producing an account of ourselves. So it's like Rebecca's account of tradition in a sense. We're producing an account of ourselves. Whereas the second looks at the past as a fact. You know, what have we done? And as judges, we merely have to follow the fact, but you pointed out, in fact, that judges are always normative in the sense that they're delineating the space in which factual determination prevails, and if too constraining, there are a lot of descriptive or interpretive ways to evade it. So one way of appealing to the past is still keeping the normativity to which Rebecca had pointed us earlier visible, legible, you know, for contestation. The other deflects that question into a set of factual claims. I think I heard you saying. I call the second ventriloquizing value, but that's to say that there's still value going on, but we're not having a direct encounter with the stakes of the matter. We think we're addressing a claim of fact. And I just wanted to throw that out there because I think that we can see across these accounts of First Amendment law that judges are never stopping being judges in the sense of enlisted in some practice of stare decisis, to which these claims on the past are playing some role, often redirecting and disruptive is your provocation. And that's just very different than asking if they're historians. So I'm just sort of throwing that back to say, am I hearing you correctly?
Yes, I think you are. I would add to that, though. I think maybe I would maybe to be more sympathetic to what the court's doing, in or to just add to the account, maybe. There's another way to think about the difference, which is what role is, how are we thinking, how are we reaching normative judgments about history? What are we doing with historical evidence to reach the conclusions we do? So in the first, what I call deep dive history or history as principle, I think it is a much more straightforward, maybe easier inquiry in which we're looking at what the people in the past said were the values and principles that they were trying to advance. And that's what matters more than the practices, because what is so interesting, I think, about Thornhill and Bridges, but also, we go outside the First Amendment to, I think, similar kinds of acts in Griswold, other areas where we're doing this kind of deep dive history. We're trying to look at the sort of underlying principles and claims. You're often discounting the practice. You're saying, well, the practice was insufficient or inconsistent with the principles that they're articulating because of this misunderstanding. So in Thornhill, for example, there was no overbreadth doctrine, and we know historically that the way in which the First Amendment, what was considered protected speech or this well-intentioned speech on matters of public concern, was very narrowly construed through much of the 19th century. And by the time we get to Thornhill, the court is not interested in that. It thinks that's a misunderstanding of what kinds of speech play a role in democratic self-government, because they have a different understanding of democracy and a different understanding of rationality and how people speak and communicate. And so they're disregarding the practice, but they're focusing on the historical principle to reach this normative judgment. So they're not trying to reconstruct the history in its own terms at all, but the thing that they're focusing on is the principles. I think what Stevens is doing, and maybe also Czaplinski, although I think, because you see elements of this, as Michael made clear in the New Deal cases, Czaplinski and Haig both do something like this, but very loosely, and the court's not at all committed in the way it is today to following this up. It's looking much more at the practices and abstracting away from that a set of principles that I think people at the time would not have articulated. So the court, both in Czaplinski, I think poorly, as I've argued, but also in Stevens, looks at the history of speech regulation and says we can abstract from that a fundamentally libertarian principle that speech is to be protected except for these particular categories. And I think that's not actually the principle I would glean, because I think they're only looking at certain areas. They're only looking at the cases. They're not really looking at it's a very narrow view of history. But it's a focus on practice that we're then going to glean out principles. But they're our principles. They're not principles that look anything like the principles people in the 18th or 19th century were articulating when they're talking about speech. And so you reach what turns out to be an extremely different normative view of history. But in both cases, we're focusing on certain things in history. In the first case, the principles, not the practices. And in the second case, the practices and not the principles. And I suppose you can reach your own conclusions about which is better to do. Now, whether or not you could do a kind of, let's look at the practices and glean out the principles better than the court has done in Stevens is a question. But I agree with you entirely in both cases. What we see is not history, as a historian would do it. We see an effort to make sense of both the past and the present of our laws.
Oh, sorry, and Judd, I don't want to be heard to be trashing here.
Yeah.
I am not. I think that and I want to hear what Judd's going to say. I think that this is one of the richest forms of legal normative argument, and takes so many forms. Our discussion today has only touched on a few of them. And what's astonishing about it when you start to look for the forms of it is to realize how pervasive, how plural, how constitutive, how compelling it is to us imaginatively as we try to live with one another. So I want to go back to Judd, but I don't want to be hurt. Because we might be producing a past as we're arguing with one another doesn't mean that it's fake, it's false, it's inessential. I'm saying it's constitutive, and I'm not saying that the role of historians is not relevant here. I'm just saying it's somewhat distinct, and it needs to intersect with it differently. But I mean this to be respectful, actually. Judd.
Yeah, so I think there are two really important developments that are happening in the 30s and 40s that can help inform the discussion we're having. So one of them is that the court is fundamentally used to thinking about free speech principles in terms of the common law, and this is the way that courts usually develop First Amendment doctrine and related state constitutional law speech doctrine. It was just part and parcel of the common law, which gets back to my earlier point about custom and reason. The countervailing point that sort of sets us off on the modern trajectory is the court gets rid of the idea that there is general law, that the common law and constitutional rights are actually interwoven, sets us on a path where state common law is one thing and federal constitutional law is another thing. Then you have a court that is very antagonistic, Justice Scalia in particular, very antagonistic towards the idea of state common law judging, which now in a post-realist age is judges making law, adopting an entirely different perspective on what we should be doing in constitutional law cases, which are now starkly distinguished from state constitutional law cases, and that's where we are. So to do this in a historically informed way, I think requires grappling with the way in which the founders didn't starkly distinguish those things, and people up to the 1940s didn't either.
Can I just add one sentence?
Okay.
One sentence to what Judge just
Yeah.
said? Just to emphasize the pluralist nature of this historical inquiry, I think then we've just identified at least 3 different ways of doing history. Because I think you should, or judges making sense of the past, because this common law form of judging is also a claim about history. Always and inevitably, but it's looking at different forms of history. We're looking at the prior precedents as the objects and the agents of history that are themselves supposed to rely upon or reflect traditions that are outside the courts. But we are looking primarily at the courts. So we have at least 3 different strands here, all about history, all doing it very differently and all reaching different conclusions.
Okay. So we're at time, but Michael does have
Oh,
something
no,
that,
if
no?
we're- If we're at time, I don't want to.
I think you do have some privilege here if you want to take it.
I
exactly.
am not a person of privilege.
All right. Well, with that then, we'll wrap up and look forward to seeing those of you next time.